hopeful that the court's decision will give administrators better guidance and clarity on their roles, administrators across the nation, and so that school officials can go about their day-to-day duties without the risk of legal liability.
5 years ago, high school student Joseph Frederick held up a sign that read, "Bong hits for Jesus" at a parade. It got him suspended for 10 days. But was the teen just exercising his right to free speech? That's up to the U.S. Supreme Court, heard the case today. Joining us now, Pepperdine University Law School Dean Kenneth Starr, who's also the attorney for Deborah Morse, the school principal. Also in D.C., Jason Brandeis, legal director of Alaska's ACLU, who is representing the suspended teen. But first, Court TV Washington correspondent Savannah Guthrie has the latest. All right, Savannah, really, I sort of harken back to, what was it, 1969, the armband case that we all think about, free speech and students. Is this case as important, and how did the arguments go down?
Well, it has the potential to be that important. It has the potential for the Supreme Court to set down the rules about how far the schools can go in regulating free speech. The arguments were very lively today. I don't think it was easy to see on what side any of the justices fell. And a lot of them were puzzled by this sign that the student posted that said, "Bong hits for Jesus." A lot of justices spent time saying, what does this mean? Is it a pro-drug message? Justice Scalia thought it was pretty obvious that it was one way of saying smoke pot, it's fun. But other justices weren't so sure. Justice Ginsburg said it's really nonsense. And another justice said it just seems like a provocative kid's statement to me. And it's an important issue because if it's a pro-drug message, the justices might be more likely to say, okay, the state, the schools can regulate it. If it's just free speech, if it's just nonsense, well, maybe this isn't something where they want the schools to crack down.
All right, well, let's get it. And I told the gentleman that they don't have to re-argue this case between the two of them, but just state their respective cases. So let's hear from Joseph Frederick's attorney, Jason Brandeis.
Well, our case is very simple and very straightforward, and that is simply that the speech at issue in this case, the banner that Mr. Frederick displayed, which had a very provocative but nonsensical message, was pure free speech. It was not a message that condoned or promoted drug use, but even to the extent that it could be considered to promote drug use, it was protected speech because it did not interfere with the educational mission or the educational process of his school.
And it was, as I understand it, on a public sidewalk. Yes, this was sort of school-sponsored in the sense that the school let them out to attend the Olympic Torch Parade, but they weren't on school property at the time. Is that correct?
That's correct. The students were released from the school to be able to go down to the street to watch the Olympic torch be run by, but not all of the students actually went down to the street to watch the torch. Many just left or went to hang out at other locations. And school was definitely still in session, but they were not on school property, and all of the students were released and allowed to leave the school at the time.
All right. Ken, your response?
Twofold. First, it was a school-authorized event. It was a school assembly, and to watch the Olympic torch, you can't stay in the gym or in your classroom. And there were, in fact, clear rules that the students were to remain in community together. They didn't stay with their class, but it was a school event, and everyone has agreed with that, although that was part of the re-argument. But here's the key. Can the school maintain control over students when they're on a field trip? Can they also interpret messages as long as the interpretation is reasonable? And this is where Jason and I may have to just agree to disagree. Deborah Morse, a school principal, interpreted the message on the spot as promoting drug use, and for that she now faces, because the court below, the Ninth Circuit, said she's wrong. For that judgment, she is now facing punitive damages, and that's one of the reasons the Chief Justice of the United States, in the very first question to the able counsel for Mr. Frederick, said this case is about money. It's not about free speech alone. It's about money, because what Mr. Frederick said is, I want punitive damages from Deborah Morse, a career educator. That's just wrong.
Okay, well, that does take away a little bit, because you and I could get into the whole legality, arguing about whether there even should be that sort of recourse. But let me take back to the argument about free speech, which I think is what concerns most people, other than the teacher who might be looking into a
Oh, no, you're absolutely wrong, Catherine. It is concerned to every school board and school principal in America.
I understand. I'm talking about the generally people who've heard about the case and are talking about the free speech issue, because something that it's my understanding the administration lawyers, and I'm not sure if you specifically made this argument, said something that really concerned me, that basically there ought to be a broad rule that public schools schools do not have to tolerate a message inconsistent with its basic educational mission. That statement, that position, that if you disagree with our basic mission, we can shut you down, brought even the religious right out supporting Frederick. They're saying, we might want to say something religious. Their students might want to say something political that's not sexual, it's not advocating drugs, and all of a sudden that kind of broad rule could shut us down.
And we agree that the rule could in fact be too broad so as to violate the guarantee of free speech that students enjoy under the case of Tinker involving the passive display of an armband. We support that decision. The Juneau School Board believes in free speech, but we have drawn a line, or the Juneau School Board has, and said you cannot promote drugs, you cannot promote alcohol, you cannot promote tobacco. Now, the particular test that you articulate is actually the test that the Supreme Court of the United States articulated in a case called Frazier involving a sexual innuendo speech some 22 years ago, and then it re-embraced, it being the court re-embraced that same test. That very test that you used, or that you articulated, was re-embraced by the Supreme Court in an opinion by Justice White for a majority of the court. Now, it is clear that the current court's change, is rather concerned about the potential breadth of that.
Yeah.
The assurance we tried to give was, look, free speech does reign as long as it's not disruptive, and here we did say, a drug-free environment is at the absolute bedrock foundation of an educational mission, because school children cannot have this exposure to drugs, or at least in loco parentis, the schools have to guarantee the parents that this is a safe place.
Okay, it is a high school. Nobody was smoking dope. Ken, let me ask you, if there was no fear of punitive liability, if there wasn't a pocketbook issue here, would you say they can do what they want, we're not worried about it?
Oh, I'm sorry. I thought you were asking
basically,
Jason.
You say that's at the heart of it. If administrators are not worried about dollars as a liability issue here, would you let the kids go and say fine?
No, of course not. Of course not.
Yeah.
Because they cannot promote drugs. But Catherine, do not overlook. This is why the School Boards Association and school principals came out and said, please, public education is difficult. Don't subject us, if we get the judgment wrong, don't subject us to the possibility of punitive damages. It's part of what's wrong with our litigation system.
Okay, well, I don't know that I necessarily disagree on that point, but Jason, again, setting the money aside, what about the free speech issue? Because, you know, I got to tell you, I'm really basically a libertarian. You know, these kids are off the property, bong hits, say you use a bong to smoke tobacco as well as pot. You can argue this is a drug message, but you could certainly argue it wasn't. What's the bottom line in your position?
The bottom line on our position is that the stance advocated by the school board goes way too far. They are asking the court to rule that any student speech that conflicts with a message put forward by the school is de facto not protected under the First Amendment. And that is wholly inconsistent with the body of case law that the Supreme Court has dealing with student free speech issues.
All right, and I've got about 20 seconds, and I'm curious, Savannah, if you found an interesting split, because when I read what Alito said in there, I thought, this could be a very interesting division of opinion.
Well, you know, the old reliable ideological lines weren't that apparent today. You're right. Justice Alito was concerned about schools defining this broad educational mission so that any speech that undermines it would be violative of the school's rules, and he was concerned about that. So I think it'll be very interesting to see what the justices do, their decision do sometime before the terms end in June. Okay,
an intriguing case. Savannah Guthrie, Kenneth Starr, Jason Brandeis, much appreciated. And coming up next, your thoughts on music mogul Phil Spector's violent past and upcoming trial.